Welcome again to today's edition of Florida Appeals Journal. I'm Jennifer Carroll, and today I think we're going to discuss an issue of great importance to attorneys and their clients. When is the right time to file your motion for attorney's fees in the trial court? And not really a very easy issue. Traditionally, going back years ago, the standard was for the trial judge to determine a reasonable time. Well, did you file your motion for attorney's fees within a reasonable time after the final judgment or some other event? And that caused a lot of confusion, very strict standard. So then Florida Rules of Civil Procedure, you have a rule that was developed in an attempt to set up a bright line test. So it would be 30 days, about 30 days after final judgment, including judgment of dismissal, service of voluntary dismissal. And then there was another change in 2010, and we're going to go over that. So the issue right now that we're discussing is the timeliness of your motion for attorney's fees. And as you know, in the trial court, we've discussed this before, you're going to have a basis either in contract or a statute to be entitled to attorney's fees. You may also, on 57105, and I think we've addressed that in other discussions, there are other standards. But when you're at the end of your case, you're going to want to, if you're entitled to fees under a statute contract, you're going to want to file your motion. So you got to follow procedure. Now, the rule that I was just mentioning is Florida Rule of Civil Procedure 1.525. Now, that current rule states any party seeking a judgment taxing costs, attorney's fees, or both shall serve a motion no later than 30 days after filing of the judgment, including a judgment of dismissal or the service of a notice of voluntary dismissal, which judgment or notice concludes the action as to that party. That's the recent version of that rule. Seems pretty straightforward, you would think, but it never is, right, in the practice of law. The Fourth District Court of Appeal, in a case that I was personally involved in, not just on the appeal, but I was trial counsel, the Fourth found it necessary to render a detailed opinion on this rule and what it means and what is the right time to file a motion for attorney's fees in a civil case. And I'm going to give you the cite to this case, Ward v. Lieber, Lieber, 355 Southern 3rd 430. And that was a 2023 case, January, that opinion came out. And in that case, I'm going to talk about that particular case too, and from the opinion, because the analysis I think is very significant and will answer a lot of questions on this issue. So in the Ward case, the underlying case involved a dispute between siblings regarding the administration of their late mother's estate. The plaintiff was PR/N individually. She had filed a multi-count complaint against the defendant seeking damages under 772.11. That's called civil remedy for theft or exploitation. So you have a fee provision in that. So on behalf of the defendant, we filed a motion to dismiss count 3, which is a very significant count. And the trial court granted that without prejudice, on July 31st, 2019. The plaintiff ultimately, after discovery, the case went on for almost 2 years. The plaintiff ultimately filed a notice of voluntary dismissal. That was in 2021. So within 30 days of the filing of that notice of voluntary dismissal, the defendant moved for attorney's fees, filed her motion. The trial court first granted it. Then the plaintiff moved for a hearing. And then without holding a hearing, the trial court reversed itself, granted the motion for rehearing, and entered an order denying the defendant's motion for fees. A crazy situation. So the defendant then had to file a motion for rehearing, and the trial court denied. Then it goes up on appeal. So on appeal, the defendant's position, our position, was that the plaintiff's notice of voluntary dismissal that was filed in 2021, that's the event that triggered the 30-day limit, right? Deadline for filing a motion for attorney's fees. The plaintiff said no. We believe trial court granted or properly denied, after a rehearing, the defendant's motion for fees because the earlier order by the trial judge, which dismissed without prejudice that major count under that statute, which allows for attorney's fees, that triggered the 30-day limit for filing a motion for attorney's fees, and not the subsequent notice of voluntary dismissal. Always seemed to me the rule was very clear, but obviously not, because the trial judge changed her mind, and so obviously confusing. So the appellate court, of course, did the right thing to write an opinion. So the appellate court, de novo review, of course, held. We agreed with the defendant in reverse. The court cited Rule 1.525. Again, any party seeking a judgment, taxing costs, attorney's fees, or both shall serve a motion no later than 30 days after filing of the judgment, including a judgment of dismissal, or the service of a notice of voluntary dismissal, which judgment or notice concludes the action as to that party. You know what's interesting is before the last amendment, which I believe was 2010, the 2010 amendment added that language, concludes the action as to that party. Before that, that wasn't there, so you just had 30 days, no later than 30 days after the filing of a judgment dismissal or service of a notice of voluntary dismissal. So the 2010 amendment made it crystal clear which concludes the action as to that party. So the appellate court, delved into, I wouldn't say delved, just cited some of the general rules about an order is final if it, quote, disposes of the cause on its merits, leaving no questions open for judicial determination except for the execution or enforcement of the decree if necessary. So that was a very actually important point in the appellate court's decision. They believed that the 2019 order by the trial judge was not final, and it certainly did not conclude the action as that party. Quote, the appellate court stated, quote, here the trial court dismissed count 3 of a multi-count complaint on July 31st, 2019, but the count related to the same common set of facts as to the remaining counts, and the trial court's order dismissing count 3 was without prejudice and with leave to amend. When an order partially dismisses a complaint, leaving claims related to the same facts and parties, the order is non-final and not directly appealable. That's actually really the current statement of the fundamental law on that issue. Thus, the order disposing of count 3 was neither final, nor did it conclude the action as to either party. The order, therefore, did not trigger the 30-day time limit within which to file a motion for attorney's fees pursuant to Florida Rule of Civil Procedure 1.525. The court stated, had the motion been filed after the dismissal of count 3, it would have been premature. So the defendant was correct in the procedure, and that was actually my feeling was that it would have been premature to file a motion for fees with that dismissal without prejudice early on. Now, there is a case out of the Fourth, it's 2005, it's called Landmark at Hillsborough Condominium Association versus Candelora, 911 Southern 2nd, 1272. It's a 2005 case, and in Ward, the appellate court had to distinguish that case because on its face, the Landmark decision appeared to warrant an affirmance. But the appellate court, in the Ward opinion, said it really didn't apply to the facts of this case because the issue argued in that case on appeal was not whether the order under appeal was final. There was neither a judgment on the merits nor a notice of voluntary dismissal to trigger Rule 1.525. So I would encourage you to read that opinion because it gives a really great explanation of the rule, what it means, and it distinguishes Landmark, which you should be aware of course. Now, there was a special concurrence by Judge Artow, and that's a very good concurrence, of course. I encourage you to read that. Now, what Judge Artow did is he concurred in the opinion because he believed landmark, and rightfully so, had been superseded by the 2010 amendment to Rule 1.525. Quote, the version of Rule 1.525 interpreted in landmark was subsequently amended by our Supreme Court to clarify that the 30-day deadline to move for attorney's fees is not triggered until a, quote, judgment or notice of voluntary dismissal concludes the action as to that party, end quote. And that cites to the amendment, you can find that 52 Southern 2nd, or I'm sorry, 7th 3rd, we'll be on a second now, 579, 590. And it amended Rule 1.525 to add the clarifying phrase, quote, which judgment or notice concludes the action as to that party. So accordingly, according to the special concurrence here, landmark has been superseded by rule change and has no precedential value in interpreting the current version of the amended rule. So that's very, very important, because we needed a statement by the appellate court on, what is the status of landmark and what did the amendment, 2010 amendment to Rule 1.525 accomplish. So I encourage you that, of course, I thought it was an excellent opinion. And it's a very, it's a significant issue, significant procedural issue. So thank you again for joining us. Again, if you have any questions, please feel free to contact us here at the Florida Appeals Journal. Thank you very much for your time today. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.